The Firm, India's only show on corporate law, tax and audit matters.
He took over in October 2011, and it is under his watch that the Competition Commission of India has grown into one of India's most important regulators. But it hasn't all been a bed of roses. Today on The Firm, we speak to the outgoing chairman of the Competition Commission of India, Ashok Chawla. Mr. Chawla, thank you very much for your time. I'm going to start by talking about merger control regulations, which came into force around the same time that you took over at the CCI. And I think in that period of time, you all have cleared over 365 merger filings, and only in 3 cases have you asked for any remedies. I'm going to start by asking you for your assessment of how the merger control regime has run so far.
As you mentioned, we've handled close to 400 cases so far, but a lot of the cases which have come, and I think there are reasons for that, a lot of cases have been those which involve intra-group restructuring, sale of equity, etc., which without much impact on the competitive landscape. So we've therefore not felt the need to go in detail into many of those cases, and it's only in a few of those that we've delved deep.
Would you say, sir, that the current merger control regulations are good enough to deal with both the influx of cases and the type of cases coming into the CCI, or would you call for changes to the merger control regulations? You had already told me in a previous interview that we did in the middle of last year that in fact the exemption threshold for target enterprises expires in March 2016. That is, the notification regarding that comes to an end in March 2016. Can we expect to see some changes when it comes to exemption thresholds?
The exemption threshold and the notification that you're talking about is something which the government handles. They do consult us, and it will be a call which of course the government will take at the end of the day. But looking to the fact that business and industry need a shot in the arm, that the ease of doing business is very critical for the Indian economy at this stage, and the government is focusing on that. I would think that there is perhaps a case for the notification and the exemption which it brings in its wake to continue for some more time. That is also useful from the point of view of the Competition Commission, in that it will give us the bandwidth and the time and energy to focus on cases which are really big and important.
In your opinion, do you think that there is a case to be made for enhancing the exemption limits, thereby asking for fewer transactions to come to the CCI in the case of merger control?
Maybe may not be a bad idea. Yeah, I agree.
Sir, in the last 4 years, we've seen 4 revisions to merger control regulations. The last one being, I think, in the middle of last year, which is 2015. And from what I understand, a 5th one is already in the offing.
So there are issues which have come up in terms of who should be filing who is authorized to file a merger notification, particularly in relation to multinational companies. When should a notice be invalidated? Should parties be heard before invalidating or not? So these are questions which have bothered the companies which file and their intermediaries, and we hope to resolve many of these issues in this round of change of regulations, which is, I think, ready and is just going to be notified in the next few days.
Well, it's interesting that you're looking to revise the invalidation provision, because in fact when you introduced the concept in the draft merger regulation amendments last year, there was a considerable amount of criticism. I had put that to you in a previous interview when we spoke of it, and you had said that the philosophy or objective behind this is very often we get filings which are incomplete, which do not give the entire picture. So there's a lot of to and fro between our people in the CCI and the companies or their lawyers who have filed. So what we really want is that there should be a little bit more rigor and discipline in the filings which take place. You had defended the idea of introducing invalidations. I'm told since then there have been about 18 merger filings that have been invalidated. Please correct me if I'm wrong. You are now reviewing invalidation. Would you consider doing away with it altogether or amending the provision to allow for, let's say, more clarity as to what will be invalidated or more clarity on how a hearing regarding invalidation would proceed?
Yes, we thought that invalidation was necessary so that we could bring in more rigor and discipline in the filings that take place, and the Commission and its officers get the kind of material which they need to be able to concentrate and focus quickly on a case. But we found that very often it tends to get into a different loop, and sometimes invalidation takes place maybe where it's not entirely necessary, etc. And there have been protests. There were protests then, there are protests now. So while we are retaining the provision, what we do want to ensure is that we give the parties a hearing so that they know what our viewpoint is, and if they are going to correct it and remedy it immediately, then that process, that burden is lessened for them.
The other thing that I'm told might come up for consideration when you look to amend the merger control regulations is more clarity on filing triggers.
There will be clarity on what is the trigger point in terms of the other document. But on market transactions and whether they form part of the transaction as a whole and whether it's linked in any manner, etc., will necessarily depend on the facts and circumstances of each case. So where it is in preparation of and is integral to the overall transaction, then well, it will be taken as something which should have served as a trigger. So I don't think there can be very clear boxes to determine these kind of things. Very often it will depend on what the facts are.
I want to come back to the 3 instances in merger control where, or rather 2 instances where the CCI has ordered structural remedies. The first one was the Sun Pharma Ranbaxy transaction, and the second one was the global merger of Holcim and Lafarge, which had implications in India. Now, interestingly, in the Lafarge situation, CCI has ordered the divestment of certain assets to remedy the ill effects of this global merger. But government policy is proving to be a hurdle in the ability for the company to be able to sell those assets, because the plants cannot be sold with the mining leases because the transfer of such mining leases is currently not permitted under government policy. Thereby, in short, the structural remedy that CCI directed is proving to be at this point in time difficult or impractical to adhere to. I'm asking for your views, not specific to this case, but otherwise, on what happens when CCI asks for a structural remedy that somehow government policy makes difficult to fulfill.
Well, whether it's this case or any other case, if it so happens that by the time we give out a structural remedy, which is an order of the Commission, but that is preempted, so to say, by a legal change, then obviously the parties will have to comply with the legal change, which is the situation in this particular matter. Now, this is something which is more like a black swan event. It's not going to happen every day. It happens very rarely. It happened in this particular case that you're referring to, because at one point in time, we gave out the order on structural remedy, and around the same point in time, maybe slightly later or so, the Mining Act was amended. So these kind of situations don't arise in normal cases. They have arisen in this case, and I think the process on the part of the company to come back with an alternative proposal is already on the table. So that's not a major issue. But to go back to your point, which is a larger issue, I think the law of the land, which may change, necessarily has to be kept in mind in terms of the application.
Would it be fair for me to assume, based on your response, that in this particular case CCI is reviewing the structural remedy that it ordered based on the alternative being offered by the party?
Yes, we are, in the sense that the earlier proposal was to sell 2 assets. Then the company has withdrawn that and put a proposal which is more comprehensive, which covers this particular area where we had issues from the competition point of view. So we are examining that. I presume we will have no objections as long as this part is taken care of and it becomes a wider proposal on the part of the company which has been asked to divest.
To move to what is often referred to in competition law jargon as behavioral cases, and I'm going to start by asking you for your assessment on how the CCI has fared in acting against both abuse of dominance as well as cartel matters.
Well, we've made a reasonable start, but I think we perhaps could have done better, and maybe we should be doing better in the years to come. And let me elaborate by saying that partly, of course, not too many substantive major cases have been brought to our notice. That's one. Number two, we haven't been able to, given our constraints, been able to generate good cases, robust cases, suo motu, which the law does allow us to do. Thirdly, in the cases that have come, we've taken quite a bit of time in terms of the investigation at the level of the Director General. And then, of course, once the judicial process takes over, which has its own dynamism, it's taken quite some time. Maybe this is a symptom of the teething troubles which a new organization and body goes through.
Mr. Chawla, what would you mean by teething troubles?
Given the fact that we are quite stretched as it is in terms of the internal capacity and certainly the investigation capabilities, the number of suo motu cases have not been more than 5, 7, 10% of the total number of cases. And while the suo motu cases are no substitute for what should normally be coming from parties which are affected, they can contribute to that stream. So on both sides, even the filings that take place, I think, are totally inadequate for a country of the size of India, for a 2 trillion economy.
I do want to come to my final theme, sir, and that is institutional capabilities and processes. And the first one I'm going to talk about is the average time taken, whether it is for merger filing clearance or even cartel cases, which I'm told are often delayed. Now, in merger filing clearances, I'm told that the average time the CCI used to take at the beginning of the imposition of the merger control regulations was about 29 days. You yourself have alluded in a previous answer that that timeline has now stretched to about 55 days. In your amended regulations, you've bought yourself 60 days. What's gone wrong? Why is it taking so much more time? And should we be worried because now the burden of the number of M&A cases coming to the CCI has increased? In fact, your office has put out numbers that show that, you know, the number of filings has increased every single month over the last several months.
You're right, absolutely right. I have myself acknowledged this, and that we are now in the process of changing our operating procedure at the level of the officers who examine this to be able to bring down in the vast majority of cases which may really have no major competition concerns back to the 30-35 days or so that we used to take earlier. And it's only in the maybe 10% cases which require detailed attention that we will need to take more time. So you should watch this space. And I think in the next 3 to 6 months, you will see a clear change from what has happened. And why it has happened is that there were many more filings which were taking place. Our people were trying to go into details in respect of even cases where perhaps there was no great need for intensive study. So we've brought in a number of changes. We brought in engagement with the parties at the level of a group of members, etc., which should be which would enable that the larger perspective is seen before the matter comes to the full commission for a decision.
I'm told that you know, CCI proceedings in cartel cases are also considerably delayed. For instance, one lawyer gave me this illustration that in one cartel case, the CCI passed its prima facie order in 2013, but the investigation began only in 2015. What's gone wrong, sir?
No, I don't think it could take that long unless there was some legal intervention and something to prevent that investigation from going forward. I mean, the starting of the investigation couldn't have taken 1.5 years unless there was the hand of the DG or the commission was restrained by some court. It's possible.
But would you say that you all are understaffed? Because I'm told that in the early days of the CCI, the IIM Bangalore did a study that suggested that there ought to be 240 professionals staffed at the CCI and an equal number at the Director General's level, and this by about the 3rd year of the CCI's functioning. Whereas today I'm told that the total staff strength, the professional staff strength, would not cross probably even 100 or maybe just a little over that. Are you considerably understaffed and maybe even underfunded and therefore under-resourced?
The IIM study had given a number close to what you are mentioning, probably not that high, but they had indicated a number which was a good, I think 9 or 10 years ago. The cabinet approved, the union cabinet approved a staffing strength which is close to 200. And this was about 7 years ago, and we are at about 70%, 65 or 70% of that full complement of staff we have today. We do supplement that because we are somewhat short of professionals. We do supplement that by engaging experts and research assistants, which the law and the regulations do allow us to take on board for shorter periods of time on a contract basis. So I wouldn't say that we are very understaffed, but yes, we need to build up the numbers both in the commission and more so in the DG's office, where the staffing comes directly on deputation from the government. They are not part of the commission staff, and we can't interchange with them. They are supposed to be hands off in terms of the work that they do and also the streams they come from. So there is some engagement that we are having with the government on filling those posts and perhaps changing the recruitment rules there. But it's a process which is ongoing, and Rome wasn't built in a single day. So it's going to take some time. But I wouldn't say that we are short in terms of resources. Whatever money we ask for, the government provides for that. We've recently asked for quite a bit of money to move into a space which the government agency is building in one part of Delhi, the National Buildings Construction Corporation, and government has, despite all the difficulties, generously found the fairly substantial sum which we will get over the next 3 years, so that the commission can then move into its own premises as against the rented premises that we are in. That's where we stand in terms of staff and funds.
You have spoken of financial autonomy in one of your previous interviews just this last week or so, and hence I asked you that question on whether you thought that the CCI was seriously under-resourced. Have you made any suggestions to the government on how you can have financial autonomy? For instance, your parallel other regulator, the Securities Exchange Board of India, is an autonomous body financially.
See, the point that I was making was, and that holds good, is that while on the one hand we are not, we get the kind of money that we need, but it's that we have to necessarily go to the government for everything, because most regulators, and that's what I said in an interview, and when I said most, my hint was at SEBI, which is not included in that category. The reason is that most regulators are not able to generate adequate income of their own. Therefore, you have to rely on funding from the state. Now, one option is that every year you go, you get money, and well, you continue, which necessarily means that every kind of stipulation or rule of the government in terms of recruitment, in terms of salaries, in terms of compensation, in terms of all the rules and regulations of the financial variety would apply. The other is the kind of flexibility which, let's say, the Reserve Bank has or the SEBI has, which is one of the newer regulators. They are self-sufficient, so they are in a position, therefore, as a result of that, in a position to to decide the staffing pattern, to decide their broad levels of compensation, which of course will not be very much out of line with what the government pays, but they have flexibility.
So, Mr. Chawla, let me put it this way to you. Should CCI be financially autonomous as SEBI is?
No, I don't think it will ever be. Can't be.
It
Because
can't be.
SEBI deals with a host of intermediaries, and they have and the fees which they collect and have collected over the years have brought them to that situation. Now, the only fees that we earn is from merger filings, and there also I find very often when we increase it a bit, there is a howl of protest. I mean, while the companies may be very happy to pay the lawyers fancy sums, but when it comes to paying chicken feed to the regulators, there are protests. So that's, in any case, that apart, that's the only avenue that we have, and I don't think that will at any stage make the Competition Commission self-reliant.
Let me now come to what probably strikes the sorest note in your 5 years at the CCI, and that is the cement cartel order that was heard on technicalities at the Compat, and where the Compat found that the principles of natural justice had been violated. And so I'm going to read from that order. The Compat said that at the cost of repetition, we deem it appropriate to observe that even though he was not present during the hearing held on 21st, 22nd and 23rd February 2012, the chairperson not only participated in the decision-making process, but also initialed each page of the final order, which is mentioned above, is strongly indicative of the fact that he had authored the impugned order. It goes on to talk about why you ought not to have done that. It says it is a matter of mystery that without having any idea about the arguments advanced by the advocates representing the parties, which lasted for 3 days, the chairperson of the commission could become party to the final order, which resulted in the imposition of penalty of over 6,100 crore rupees. It must be remembered that the rule of law is an important cornerstone in our democratic setup, and principles of natural justice are required to be followed. This has been a black mark in your 5 years, probably the only one of its kind. How have you responded or reacted to what the Compat has had to say?
Well, the only response is that as the appellate tribunal has directed, the commission will hear the matter based on whatever evidence was adduced at that point in time. There will be fresh arguments, and the commission will decide the matter as directed by the Compat within 3 months. But let me say, on the issue of natural justice and the process which the commission has followed, the view that the commission has taken in all cases, and it's not only in just this case, is that we are not and we should not become lock, stock and barrel a judicial forum. That's not what is intended. We are a body of experts. That's what is the mandate given to us by Parliament.
But sir, surely you can't be saying that it's all right for a member of the CCI to not be present for the verbal arguments and only rely on the written submissions. I understand that the written submissions in themselves may be fairly comprehensive, but there's got to be some value to verbal arguments or oral arguments. That's why you all have them. And therefore, I'm curious as to why this practice prevailed in the CCI. And now, given this Compat order, would it be fair to say that this practice will no longer prevail at the CCI, even though you're not a judicial body?
Yes, this was, as I mentioned, this was the practice we've been following in the past, with a view to more what should I say, more functioning like a normal regulatory forum. But since the Compat is very specifically ordered in this particular case, this will be followed in this case, and this is what the Commission is now following. So this is a process which is part of the process of evolution.
Have there been other instances or other cases, sir, where this practice may come up, and hence the CCI order may in some sense be, you know, sort of, the case may be returned to the CCI?
Well, I'm sure given what has happened in this order, the lawyers would be looking at this aspect closely and might choose to highlight these aspects in other matters which are before the appellate tribunal. It's possible, but I'm not aware.
Well, Mr. Chawla, congratulations on your 5-year term. Thank you very much for your patience in answering all my questions. And thank you very much for repeatedly speaking to the firm in the last 5 years and sharing with us your views on competition law and policy. They've been very helpful to our viewers.
Thank you. It's been a pleasure. Thank you.
Thank you, sir.
The Firm, India's only show on corporate law, tax and audit matters.